నమస్కారం. డాక్టర్ బిఆర్ అంబేద్కర్ సార్వత్రిక విశ్వవిద్యాలయం విద్యార్థిని విద్యార్థులకు స్వాగతం.
Today's theme is copyright laws and libraries. Human beings have capacity of creation. So we have authors, artists, composers, designers, and so on. And they create a number of works like the books, poems, dramas, paintings, and so on. They have the exclusive right on their created works. The copyright laws protect their created works, ensure and protect against the illegal copying and use of these works. In libraries, on the other hand, we acquire various documents of various types like books, journals, microphones, video recordings, sound recordings, and so on, and keep them for use by the users with a motive of service. The librarians need to understand the implications of the copyright so as to provide better services, at the same time protect the rights of its creators. We have two experts in our studios, Professor Vivekanandan and Professor Sridhar from NALSAR, National Institute of Legal Studies and Research University, Hyderabad. Dr. Vivekanandan, what is copyright? Why we need copyright laws, and what are the advantages of these copyright laws?
Thank you, Professor Rao. Copyright is a legal right. Copyright is a form of intellectual property right which protects all creative works, which could be literary, artistic, dramatic work, musical work, cinematograph films, as well as sound recordings, and in the latest softwares which are protected under copyright. If you look at ordinary dictionary meaning, it just means it's an exclusive right given by the law to an author or a creator for a certain number of years to sell or to license or to publish on his own or her own. If you look at the statutory definition under law, that is the Copyright Act, section 14, talks about 4 types of segments under the copyright. The first one, as I said, is literary, dramatic, and musical works. The second one is artistic works. Third one is cinematograph film. And the fourth one is recordings, sound recordings. And computer programs and computer software has been brought under the literary ambit of the copyright.
Dr. Sridhar, so we come across two terms, intellectual property rights and copyright. So are these two terms same or different?
Copyright is one of the intellectual properties. There are various kinds of intellectual properties like patents, trademarks, geographical indications, plant varieties, and so on and so forth, integrated circuits. So one of these things is copyrights. Copyright gives an exclusive right to derive economic benefits from the created work. Suppose I wrote a book, I should draw a mechanical printing of that book. I must derive economic benefits out of it. This is the right that is protected in copyright. Because it is product of intellect, it is called intellectual property. Otherwise, it doesn't have the shape of or characteristic of property. What do we call a property? When there is some tangible thing and when we can transfer it for money, when it is transferable for money, for consideration, it is called a property. Now, how can you have an intellect turned into a property characteristic? This is what is defined by the copyright law. In a copyright law, what happens is, the law provides a sort of right to have an exclusive economic benefit, that means which is transferable, a right which can be transferred to the other. Suppose I write a book, I cannot publish it, so I have to sell it to someone. So I will license to a publisher the right of multiplying my book and derive profit. So that is the reason why it is called an intellectual property. So copyright is one of several intellectual properties.
So, copyright is a narrower term and intellectual property is a
generic-
broader term.
Yes, yes.
So, under which we study about all
Under
these
which we study the copyright law.
copyright law.
And we have separate law for all these different intellectual property rights.
Yes. Patents like other
Yes.
things. So, Professor Vivekanandan, we also come across several terms like plagiarism, piracy and infringement. So, how we differentiate or distinguish these terms in the copyright when talking about the copyright?
Well, it's a common notion that plagiarism is a violation of copyright law. It's not so. The word plagiarism means, it derives from the origin of the word kidnapping. So, which means plagiarism means if you lift any theme or an idea from any work and then apply it to yourself, it is called as plagiarism. But strictly speaking, it is not violation of copyright. Let me explain to you with an example. Let us say there is a Jackie Chan film, and Jackie Chan does a fight sequence. He is upside down in a rope, jumping from one rope to another rope, and he does a fight sequence. Let us presume after the movie is released, the same fight sequence is enacted in a Telugu film. You may critique that there is plagiarism in the sense there is some form or theme lifted from another film, but strictly speaking it is not copyright violation or copyright infringement, because one should understand the basic thing of copyright is an idea is not protected, a theme or a form is not protected by copyright law. When an idea becomes an expression, so an idea turning into an expression, and that expression is protected. So, if you take the same film clipping and then put in your film, it is a copyright violation of that film. But if you have done a different film using the same fight sequence, it is not a copyright violation, which amounts to plagiarism, not exactly a violation of law. Whereas piracy means straight away counterfeiting a copyrighted work. It could be a book, you copyrighted book, a publisher has the license, but you take that book and reprint without the permission or license from the copyright owner, that becomes piracy. Same way you take a software and then multiply the software or copy the software or CD-ROM, you either use it or you sell it, it will become piracy. The act what you do of copying illegally, counterfeiting is what you call as piracy. Whereas infringement means it's a term where you violate some part of the copyright. It means if you translate the work of somebody is having a copyright and you translate that without their permission, it may amount to infringement. You do an adaptation without permission of a copyright owner, it may be infringement. Or you broadcast something which is owned by somebody else, then it is an infringement. So, infringement is a very broader term. Piracy is a term which is used for straight away counterfeiting and selling, whereas plagiarism is often misquoted telling that it is copyright violation. It is not so. It is only lifting some idea and theme which under the copyright jurisprudence it is not an infringement.
And I can add one thing.
Yeah.
Piracy is a straightaway crime.
Yeah.
It can be easily proved.
Yeah.
Whereas infringement can be justified. Piracy cannot be justified. Infringement can be justified. Suppose it is a fair use for a fair use or a fair dealing, it can be justified. Whereas plagiarism will not come into the purview of an offence at all.
Yeah.
So that is the range of difference. Plagiarism is of course an immoral thing. One should not copy something. Whereas infringement is, if it is proved, it can result in some kind of compensation payment like thing. Piracy is straightaway crime.
Right.
These are the three differences.
And in the recent years, the copyright has come to light. So we are more conscious of the copyright nowadays. So how it came into more focus in the recent times?
This is all because of our capacity of multiplication. See, when there is no possibility of copying, there was no problem of copying. When before invention of printing press, if somebody wants to copy, he has to write it down all in his manual script, which is very difficult. Even if somebody has done it, it will not be for a greater economic benefit. But once the printing press is invented, the capacity of multiplication has been increased. And the printing produces mechanically any number of copies within minutes as the technology advanced. Now we can produce lakhs of copies within hours or half an hour also. So this capacity violates somebody's right to have exclusive benefit over the property, over the created work. So that necessitates a kind of protection for the copyright. And from this thought, from this scientific advancement, various regulations have started coming in. It was in England, after this invention of printing press, some of the publishers wanted to retain their exclusive publication rights of certain books, certain literatures. They wanted to prevent others from printing the same books and selling them in the market, in the same market. So that is the first genesis of the idea of protection of copyright. In fact, authors are not protected in the beginning, the publishers are protected in the beginning, and some terms of protection was granted to them. And again, we should know one thing very specifically. Copyright protection is not for permanent period, eternity is not available. You can't have monopoly of your intellectual property forever, it is for a limited period. So the publishers were initially granted a limited period, and that period was being expanded in United States. It all started with 1709, the Statute of Anne, and from there various revisions were taken place, regulations were introduced, and then ultimately a copyright law of UK has emerged with a specific term for the protection of copyright. Then another problem came. See, our multiplication capacity and communication industry has expanded. Now we can publish a book here and transmit it immediately in the neighboring country. We can sell our publications in the neighboring country. Then came the necessity of international regulations, international conventions, because my product, my book has to be sold only in my country for my property was the first initial notion. Now I have to sell it in the neighboring country also. So I must have a similar protection in the neighboring country. When laws are different, when the sovereigns are different, how do you protect your property in the neighboring country? Only by bilateral agreement. And this bilateral agreement is basis of international convention. This bilateral agreements expanded and various countries included in the kind of agreement, and that became an international convention. So in 1886, the first international convention, which is called Basic Copyright Convention, has come into existence in 1886. It is called Berne Convention. Here a similar protections, similar safeguards, similar terms or common minimum terms of regulation and protection were accorded to the copyrighted works in different countries. Suppose I am a member state who is a signatory, I have signed the convention, India signed the convention. I should see that nobody infringes the copyright of the book published in UK. It is a sort of according a kind of monopoly to a writer, a creative property. It may be extended to computer program, as has been rightly pointed out by my friend. It can be extended to any literary work, it can be extended to dramatic work, musical recording, sound recording, earlier they are called phonograms, and now all important internet communication. Now you are in a position to communicate within seconds to any part of any nook and corner of the world. So this necessitates the expansion of international convention, and that's what happened. In 1996, we have a couple of conventions and treaties. One is copyright treaty, the other is phonograms treaty. So these two treaties try to cover the digital advancement of publication industry and communication industry, and they take care of the rights of the intellectual creators in whole of the world. So that is the international scope of copyright. That is the reason why each country has to develop a regulatory law, and entire world also has to have a uniform regulation to protect the copyright of intellectual writers, intellectual creators. So that is the purpose, focus and necessity of expansion.
So in India also, I think we have a copyright law.
Yes.
So 1957,
Yes.
If I am right.
Yes.
So what are the major provisions in our this copyright law?
Major provisions of the copyright law is, first it defines wherein copyright subsists, and what are the various kinds of works that can be protected under copyright, and then what are the various kinds of exceptions allowed, that means what are the works which cannot be copyrighted. Then other parts of law define the exemptions, or I can say fair use, fair dealing, but what will not amount infringement and what will amount infringement, what work is protected and which work is not protected. So these are all what stated in detail in Indian Copyright Act 1957. In fact, it is not the first law. Earlier law was in 1914, which was almost similar to the UK law, and prior to UK law we were following the common law remedies, common law regulations for copyright protection and copyright infringements. Now in the 1957 law was thoroughly revised in 1984 and again amended in 1994 also. By amending in 1994, the computer programs were also brought under the protective category of the copyright law.
Professor Vivekanandan, what are the exemptions in our copyright law, Indian copyright law?
Yeah, as we did state that infringement means unauthorized use or unauthorized production of a copyrighted work. But however, the copyright law of different countries, even in Indian Copyright Act, there are certain provisions which allows use of others' work, which does not amount to infringement, and that is a category what they call as the fair use category. So anything which is for fair use is exempt from infringement. And what are these fair uses? If you look at it, especially from the viewpoint of libraries and information center and educational purposes, fair use is allowed for private research and teaching. For example, there is an article, I can take that article and circulate it among my students in a classroom for teaching purpose. So in that case, even though I don't have the explicit permission of the author, I may acknowledge the author, but there is no explicit permission from the copyright owner, but still it will not amount to infringement. Same way, another exemption clause what we have is, if you use some material for critique, you want to do a book review, you have taken the book, some parts of the book you have taken excerpts and then made a critique of the book. Then in such case, the copyright owner cannot come and tell that there is an infringement, because it is again fair use, because you are disseminating to the public. The same way, certain uses for parliamentary use, certain uses for judicial proceedings, they can use copyrighted work which will not amount to infringement. Another one is parody, what they call. Parody is a very important thing. For example, you made a film and I make another film which is a satire of the original film, which may be having the same theme, same sequence, but still the final result is that what I have done is satire, what I have done is a comical gesture. So in such case, the law permits these kind of use and it exempts from the infringement.
Exemption is basically given for educational and research purposes and also for limited use. Is it so for the sound recordings and video clippings, same exemptions are allowed?
Well, sound recordings, and if it is purely research, it again falls under fair use. That is also interesting. You see some of the film tunes are put in advertisements. Some famous tunes of a film is hit, a particular song is hit, that particular tune is used in advertisements of some other product. The question comes whether it is infringement. Courts have said, if you use some tune, change the words or use a similar tune for less than 30 seconds, it does not amount to infringement. It will still not amount to infringement because it has not affected the commercial value of the original song. So that will be a yardstick. As long as it is, the bottom line is, as long as it is not depreciating the commercial value of somebody, that will be the test to find out whether you are using some of the audio clippings, some of the musical clippings, even for commercial purpose, leave alone educational research purpose, which it can be used. Any educational research purpose, if it takes a musical clipping or a video clipping, it still will not amount to infringement.
So if it is a fair use, then we can say it is exempted.
There is one more class of fair uses, that is personal use. Suppose I have purchased a book and I am reading it for my own purpose, or I purchased a cassette, I am listening to it. So it is personal use. Or suppose I lent my book to my friend. So library lends a book to the users. Yeah. Will it come under the classification of infringement? It is not, because the books are being used personally, not commercially. So where you can distinguish between personal use from commercial exploitation, it is fair use. Whenever there is an element of profit, wherever there is an element of commercial exploitation, it is called unfair use. And when it is confined to me, suppose I purchased a video CD, I can view it. Can I view it along with my friends? Answer is yes. Yes, you can call for a small party, in-house party, and you can play that cassette and see it. But can I do it in a festival by taking money for entry tickets? No, you cannot do that. That's why those video parlors, they are nothing but infringers of copyright violation. So how do you use a particular copyrighted work is what is looked into in deciding whether it is an infringement or not. With reference to library, I would like to give an example. Can we Xerox whole of a book? Can we photocopy a whole of a book? Is a common question that we come across. The answer is, when the book is a foreign publication, when it is not freely available in this particular part of the country, you can have a Xerox copy for library purpose. But you can't start a Xeroxing machine within the library and ask for a binder to come over there and print any number of copies and make bounded copies of it and sell it. If you are doing it, it is not fair use, it is a commercial use. Suppose you are lending it, so 1/3 of it, then the question came, how much of a book can be photocopied? Is there a limit in the law? Law does not give you any limit like that. Under section 52 of Copyright Act, it says that if it is a fair use, fair dealing, you are protected. What is the fair use? Suppose I have taken 10 pages photocopy of the original book, which is a very, very important aspect of that book. In fact, there lies the exact original ideas of the author. Did I infringe the copyright law? No. Answer is, if I am using it for my study, for my personal understanding, satisfaction, or research, or for teaching, or for reviewing, I am not infringing anybody's right. Suppose I take 1/3 now, and after 1 week I take another 1/3 from the book, and after 2 weeks I will take the remaining 1/3 also, and I have completed Xeroxing of the book. Then is it a fair use? Then the question comes, suppose I have done it only for the purpose of teaching my students, it is absolutely not an infringement. So fair use is a question of fact, that means which has to be decided in each and every case. You have certain set examples which operate as guidelines, and we have to take lessons from those guidelines and understand whether it is whether this particular act is a fair use or not. I will give you another example of review. When I am reviewing a book of poetry, I will recite some of the, I will reproduce excerpts from the book, and if my extraction crosses the limit of 1/3 or reaches almost half of it, can I be sued for infringement of copyright is the question. Answer is again no. As long as I am doing it for critical analysis, study, research, and for promoting the book, by appreciating a book, I am really taking the book into the public. So I am contributing fairly to the benefit of the book and its market. So it is not an infringement. So you can't impose certain limitations, specific limitations on the infringement or fair use technology. It has to depend on each and every circumstance, each and every case. That's how you have to examine the fair use.
So we are referring to the copyright. Is it how long it lasts? So what is the duration of
Before coming to that, one important point I wanted to mention, which is a problem in terms of fair use today, people should understand is about softwares.
Yeah.
Like you are copying a book for fair use, personal use. Can you copy a software? It's a very important question, which is today in the world of internet and we are connected everywhere. So it is simply no. If it is a software, the difference between the other copyright and software is that software is always licensed. It is not outright sold to anyone. So the licensing limitations, which means it is a single user who has to use that. So you cannot say in the same yardstick in a library, I downloaded a software and then I put it in another computer, which will definitely amount to copyright violation infringement, because it is governed by licensing provisions vis-a-vis the other things like books. I buy a book, I can donate it to anyone. Nobody will ask me any question on that. But if a software I buy, I cannot just donate it to someone, because what I am purchasing a software is bound by the licensing agreements in the software. It is not an outright sale. So most proprietary software which are in the market are licensed under terms and conditions. So just I wanted to add a bit on that. Coming to your next question.
That's why when we install a software, generally we get an agreement. Unless you click on the I agree, I accept all the conditions mentioned in that. Generally nobody reads that. So then it won't go further. It won't be installed, that one. It comes out. So generally that in the software they have that version. And duration, regarding the copyright duration. So what is the duration of a copyright? Suppose I created a work or I have written a book. How long I can claim the copyright?
Well, duration, as Professor Sridhar was telling, in the beginning when publishers was protected about 12 years. The current copyright law in India, if it is a book, literary, dramatic, other works, or all the works, if you find out, the duration is author's life plus 60 years. The original act of 1957 stipulated author's life period plus 50 years. Now it has been extended another 10 years, and the current provision is that it is author's life plus 60 years that copyright belongs to the author, unless he chooses, if he chooses to license it, or if he outright sells to that will belong to the other person for 50 years from the time what he has purchased, or sorry, 60 years from the time it's purchased. So that is the copyright thing. It is similar for literary dramatic work, it is similar for cinematograph films, it is similar for sound recordings. So as long as the author lives plus 50 years, if it is purchased from the author, from the time he purchased, that particular period of 50 years will start counting.
Yeah, Professor Sridhar, we have remedies for the infringement. What are those?
There are various kinds of remedies available. There are civil remedies, administrative remedies, and criminal law remedies. In civil remedies, you can sue for stopping the continuation of infringement of the copyrighted work. Suppose somebody is copying my book, I can go to the civil court and say that so and so is my original work and so and so is publishing it, trying to reproduce. Do you know what is the infringement of a copyright? Reproducing it, multiplying the copies without my permission, without the author's permission. Author is the owner of the copyright. Unless he assigned it to a publisher, publisher cannot publish them, publisher cannot reproduce them, multiply them and sell them. So if somebody is attempting to print and distribute, I can stop them. The author, the owner, as an owner of the copyright, can stop him. The second remedy is, if my contract of assignment of copyright is not properly implemented or breached, or the remuneration or the royalty which I am supposed to get, I did not get properly, I can sue the publisher or the partner assignee of my copyright to pay for breach of contract. That is one thing. Suppose he is not coming out with the royalty details that are to be paid to the author regularly every year or every quarter as agreed upon, the author can sue for accounts. That means it can ask the court to direct the publisher to give accounts of profits to the owner of the copyright, that is the author. That is another remedy available. And one more remedy is, suppose a publisher has already prepared plates, negatives, and is almost ready to publish them. Or take the example of a cassette industry. Somebody has already duplicated the cassettes, thousands of cassettes are lying in his godown. So I can ask the court to take over, confiscate all those plates and give it to the original owner.
So we have discussed the copyright laws and their implications, general implications as well as their implication to the library and information services. So what is copyright, why we need this copyright, and what are the various conventions which have made the copyright focused into the use of it. And we have also discussed what are the exemptions, what are the infringement of this copyright, and what are the remedies of the copyrighted material. Let us thank our two experts, Dr. Vivekanandan and Dr. Sridhar, coming to the studios and enlightening our learners and also the general public. Thank you. Thank you very much.
ఈ ఉన్నత విద్యా కార్యక్రమాలపై మీ సందేహాలు, సలహాలు, సూచనలు పంపించవలసిన మా చిరునామా: డైరెక్టర్, ఆడియో విజువల్ ప్రొడక్షన్ అండ్ రీసెర్చ్ సెంటర్, డాక్టర్ బిఆర్ అంబేద్కర్ ఓపెన్ యూనివర్సిటీ, ప్రొఫెసర్ జి రామరెడ్డి మార్గ్, రోడ్ నంబర్ 46, జూబ్లీ హిల్స్, హైదరాబాద్ 500033.